Plea bargaining. Plea bargaining is an alternative dispute resolution mechanism in criminal law through which an accused voluntarily agrees to plead guilty to an offense in exchange for certain concessions, such as a lesser sentence or other mutually agreed benefits. The concept aims to reduce the burden on courts, ensure speedy disposal of criminal cases, and provide compensation and relief to victims without undergoing a prolonged trial. Plea bargaining represents a shift from the traditional adversarial system towards a more consensual approach to criminal justice. It seeks to balance the interests of the accused, the victim, and society while promoting judicial efficiency. The concept was formally introduced in India through amendments to the CRPC 1973 and has now been incorporated into the BNSS 2023. Legal provision. The provisions relating to plea bargaining are contained in Chapter 23, Section 289 to 300 of the BNSS 2023, which is corresponding to Chapter 21A of CRPC 1973. The applicability of the plea bargaining is specifically provided under Section 289 of the BNSS 2023. Object of the plea bargaining. The primary objective of plea bargaining are to ensure speedy disposal of criminal cases, to reduce the burden of pending cases on courts, to save judicial time and resources, to provide quicker relief and compensation to victims, to encourage voluntary resolution of criminal disputes, to reduce the expense and uncertainty of prolonged litigation. Cases in which plea bargaining is applicable. Under Section 289(1) of the BNSS 2023, the plea bargaining may be invoked where cases instituted on police report. A police report has been forwarded under Section 193 of the BNSS 2023 alleging commission of an offense by the accused, provided that the offense is not punishable with death, imprisonment for life, or imprisonment exceeding 7 years. Cases instituted on complaint. A magistrate has taken cognizance of an offense upon a complaint and issued process against the accused after examining the complainant and witnesses under section 223 of the BNSS 2023 and issuing process under section 227 of the BNSS 2023. However, the offense must not be punishable with death, imprisonment for life, or imprisonment exceeding 7 years. Cases where plea bargaining is not available, plea bargaining cannot be used in the following cases. Socio-economic offenses. It is not available for offenses affecting the socio-economic condition of the country. The central government is empowered to notify such offenses. Offenses against women. The benefit of plea bargaining is not available where the offenses has been committed against a woman. Offenses against children. Plea bargaining is also excluded where the offenses has been committed against a child. Serious offenses, offenses punishable with death, imprisonment for life, or imprisonment exceeding 7 years are outside the scope of plea bargaining. Procedure for plea bargaining. Application by the accused. The process begins with an application filed by the accused before the court in which the case is pending. Voluntary nature. The court must satisfy itself that the application has been made voluntarily and not under coercion, undue influence, or pressure. Meeting of parties. The court facilitates a mutual satisfactory disposition involving the accused, the victim, the complainant, and the prosecution where necessary. Preparation of report. After discussions, The court prepares a report recording the outcome of the negotiations. Disposal of the case. The court may award compensation to the victim and impose a reduced sentence in accordance with the law. Essential features of plea bargaining. Voluntary participation. The accused must participate voluntarily without any force or pressure. Judicial supervision. The entire process is conducted under the supervision of the court. Victim participation. The victim is given an opportunity to participate in the settlement process. Speedy justice. The process significantly reduces the duration of criminal proceedings. Finality. The disposition reached through plea bargaining generally results in the final settlement of the case. Case law. State of Gujarat versus Natwar Harchandji Thakur 2005 1 GLR 709. The court observed that plea bargaining is a pragmatic approach to criminal justice and helps in reducing delays while ensuring fair resolution of criminal disputes. Murlidhar Meghraj Loya versus State of Maharashtra AIR 1976 SC 1929. Although decided before the statutory recognition of plea bargaining, the Supreme Court expressed reservations regarding informal plea negotiations. Subsequently, Parliament introduced a regulated framework through statutory provisions to ensure fairness and transparency. Importance or significance. Plea bargaining has become an important tool in modern criminal justice because it reduces pendency of cases, promotes speedy justice, saves judicial resources, reduces litigation costs, encourages compensation to victims, provides certainty regarding the outcome of criminal proceedings, facilitates efficient administration of justice. In a system burdened with a large number of pending criminal cases, plea bargaining serves as an effective mechanism for resolving suitable cases without prolonged trials. Conclusion. Plea bargaining under Chapter 23, Section 289 to 300 of the BNSS 2023 is a statutory mechanism for the consensual resolution of certain criminal cases. It applies only to specified offenses and excludes serious crimes, offenses against women and children, and socio-economic offenses by promoting voluntary settlement, victim compensation, and speedy disposal of cases. Plea bargaining contributes significantly to the efficient administration of criminal justice.